institutions for historical research. Professor Ananth began his professional journey in journalism, joining the Hindu in 1991, and over 13 years with the newspaper, he reported extensively on national politics and contributed insightful editorials and articles on political developments and issues of national importance. His deep engagement with political processes and contemporary issues shaped his reputation as an incisive commentator and public intellectual. Since the inception of the Asian College of Journalism, Chennai, in 2000, he has been closely associated with the institution, lecturing on Indian history, contemporary Indian politics, legal and constitutional issues, and training students in news writing and editing. After becoming a freelance writer in 2004, he also practiced law at the Madras High Court, specializing in writ jurisdiction, labor disputes, human rights matters, and issues related to the Right to Information Act. Professor Ananth is the author of several notable books, including India Since Independence, Making Sense of Indian Politics, Politics in the Time of Churning, and Emergency Nandathu Enna, Tamil 2007. His scholarly contributions extend to articles in edited volumes, academic journals, and national newspapers, marking him as a profile and influential voice in contemporary political and historical discourse. Served as a fellow at Nehru Memorial Museum and Library, New Delhi, from May 2009 to April 2011. During his fellowship, he conducted an extensive study titled The Retreat of Nehruvian Socialist Project, a study on the political, legislative, and judicial interventions, which later formed the basis of one of his significant academic works. Professor V. Krishna remains an eminent scholar whose interdisciplinary engagement, spanning history, journalism, law, politics, and public affairs, continues to enrich academic and public understanding of modern India. So, my dear friends, please join me in inviting Professor V. Krishna Garu to share his valuable insights.
Friends, I have one request. Please forget most of the things that were said in the introduction. And to me, it's necessary to remain a teacher, and that is what I'd like to be remembered for. And teacher not in the sense of sort of examining students and their progress to submit assignments or memorize and things like that, but a teacher in the sense that something that Professor Venkat Rao said about the Ratlam Municipal Corporation case. Students who conscientiously intervene with the world and particularly intervene to ensure that the world is left a little better place than what they came into. And it is this that actually sort of leads one to talk about the Constitution. So let me sort of deal with this in three parts, and you are free to raise your hands and interrupt me. I'll keep looking at you when I'm talking, and you don't have to feel defiant, or don't have to hesitate to ask me anything at any point of time, because there are two ways of looking at it. One is to sort of give a speech, and it's not a wonderful idea, at least for me, to stand up on a pedestal and speak. But let me just sort of tell you how important the pedestal is. I think most of us are very familiar with what it involves to make a driving license. Whether you know the skills of driving or not, whether you have picked up the skills of driving or not, and even if you have picked up the skill, it doesn't make sense to anybody. Is there anyone here who has actually gone to make the driving license directly? I think all of us go through it out simply because whether we know or not know, unless we go through it out, it becomes so difficult. So what I mean is, there is something called corruption that lives among us. But at the same time, we get a little startled when we hear about a judge getting cut. when we hear about a journalist getting corrupt, or when we hear about a priest, whether it's in a temple or a mosque or in a church, getting corrupt, there's something very common about all these people and corruption when we hear about it, that we get a little startled. That is, these are all callings of professions that are placed on a pedestal, on a higher pedestal. And the priest, when he gets corrupt, or the judge, when he is actually found to be corrupt, it actually destroys or shatters the faith of a certain system. And this is exactly where the constitution or the constitutional scheme becomes very important. So let me just quickly look at how did this whole idea of a constitutional scheme come into existence in human history. Ever since the state came into existence, state not as in Andhra Pradesh, Telangana or Tamil Nadu, the state as in the institutions that command our day-to-day life. Ever since the state came into existence, which so happened in Sparta, in ancient Greece, the fundamental principle that actually drove the state, the early state, a philosophical position that actually sort of guided the early state, was that by Plato. Because Plato arrived on the scene at just about the same time his own teacher, who was Plato's teacher, Socrates, was poisoned to death by the Spartan ruler. And the reason why Socrates was poisoned to death was that he asked questions. And he began to say that it is necessary for us to ask questions. In a sense, how many of you will agree with me if I say that the sun rises in the east? All of you seem to. You agree with me that the sun rises in the east? I think all of us are wrong if we agree with that. I don't know why you agree with me. Is it because that I stand here on a pedestal, or is it because you seriously believe that the sun rises in the east?
We see that every day the sun rises from the east.
The sun doesn't rise, it's the earth that keeps moving. And this is a truth that actually shook the world. So the sun is there, it doesn't rise and fall. Whereas early civilization, people believed that when the sun sets, there's a Latin American folk story that there was somebody who actually saw that the sun was actually beginning to fall down, got terribly worried that what happens if the sun really falls down? Because when the sun falls down, life is going to come to an end. So he started walking to make sure that he should not allow the sun to fall down, like all of us actually push a balloon, or those of us who play volleyball do that. He thought that he should push the sun up rather than allowing it to fall down. But by evening, as he kept walking, he suddenly realized, felt that the sun has fallen down, and he was in a doom. He said, like, now the world is going to come to an end. He slept off, but then suddenly he woke up to a pleasant surprise that the sun was rising. And he thought, like me, there was somebody else who went and managed to push the sun up to ensure that the world doesn't come to an end. There are 2 or 3 things here. One, the knowledge that all life comes from sunlight, which is something that we all need to keep on telling ourselves. And the second and the most important part of it is the knowledge that I am not the only one who wanted the earth and the world to refine. There was somebody else who was equally good, and he managed to do that in some other part. In a sense, like, there was this whole thing that there is somebody whom I don't know, and there is goodness about it. In other words, there is land outside my own. In a sense, there is life outside my own backyard. And everybody has to sort of, care for that. But the time Socrates was poisoned to death, punished, he was actually the last of a certain era to represent this thinking of critical thinking, like, I mean, you keep asking why. You keep asking why to everything. And about the time that Socrates was put to death, and with no offense to any particular religion, the Roman civilization emerged, and along with that, what we call the earliest to the organized religion. And the earliest to the organized religion, and religion even today, has a definite answer for anything that you don't understand. That anything that is created and anything that is destroyed is not in your hands, it is God who did that. So even in the morning we heard that God bless you. Now, this is something that came in with the Roman civilization, and alongside that came Plato's relevance. As distinct from Socrates, Plato said that human beings have to be ruled. And human beings have to be ruled by an enlightened person. And he came out with the concept called the philosopher king. That the king knows everything. And I sort of want to make this point here because even in today's world, we have a kind of a thinking that those who actually sit down and take decisions on our behalf are taking those decisions for our own good. I always sort of, tell parents, not you, to watch two films in recent times. One is The Three Idiots, and the other is Tare Zameen Par. I mean, Three Idiots is a laughable film, but has got a very serious message. And Tare Zameen Par is a film that talks about everybody is very different. And the point here is, this also helps that anybody else should not be interested with the task of thinking for what is good for us and what is bad for us. And this is the influence of Plato that pervades even today in our own lives. And it also pervades in a manner that we have a set of wise men who will decide whether a dam to produce electricity. I come from a state, the eastern Himalayas, where the mountains are very fragile, and building dams saying that we need electricity that is sold to Punjab and Haryana in return for the money which is then sort of brought into private power projects and so on and so forth, have finally led to a situation where a journey that used to take about 3.5 hours by road from Gangtok to Bangalore is now taking sometimes between 6 to 7 hours for me. So I think we have been talking from the morning as to how things have improved in the last 75 years, but these are also takes that we need to keep in mind, because there were a set of people, and incidentally, I just trying to look into what is this power project business all about, and I finally found the route that there is a public-private partnership in all these power projects, and the private player in all these power projects happen to have the headquarters in Hyderabad. A project that is actually destroying the eastern Himalayas has its headquarters in Hyderabad, but of a company that is registered. Will anybody guess? A company that is registered in Mauritius. And if any one of you doing first years do not really know what it means, what is the implication of registering companies in Mauritius is, do ask your teachers and do check up on your internet, or ask Professor Artificial Intelligence as to what is shell company, as to what is a shell company, and you will learn yourself. Now, this is where a constitution and the constitutional scheme that we talk about, where Plato's philosopher king, he himself 11 years later, he said that is the most ideal option, to have a king who is all the knowledge about anything and everything. But then it is not easy to have somebody like that. So the next best option, he said, is rule of the law, the next best option. But it took about 1,000 years after Plato, or more than that, for a set of people to stop the King of England. In 1215, to stop the King of England who was marching, and tell the king, sir, you are imposing taxes on us, wonderful. We know that you are imposing taxes for the good of our kingdom. Wonderful. We are all patriotic people, we love our king and the kingdom, long live the king. But sir, henceforth, you need to consult us, you need to take our consent before you impose taxes. This was the treaty at Ready-Made, otherwise known to us as the Magna Carta, the Great Charter. And it is there actually, from there that you have what is called the House of Lords. And incidentally, it is from that legacy that the judges are addressed to in the court as my lord, or his lordship, or your ladyship. You had the House of Lords. From there, it took about another 400 years before Oliver Cromwell in 1649 declares that, we don't want a king. And in fact, the British Parliament decides to behead the king and throw the head of the king to the people. Not for long, by 11 years again, they restored the king. But now the king is not the philosopher king or the ultimate. The king is somebody who is a ceremonial head who acts on instruction from the elected representatives, that is by now the House of Commons, what we call the Cromwellian reforms. In another part of Europe, that is the French experience, it wasn't as smooth, and the people actually sort of went to the king. Who was the king then? Louis XVI, who said, I am the state. Went to the king to say, look, you cannot decide on our behalf, you need to consult us. The king said, no, I'm not going to consult you. The people assembled at the tennis court adjacent there, and the tennis court resolution abolished nobility, abolished monarchy, and so on and so forth. For another 75 years after that, the whole of Europe, there was not an inch of land across Europe. And you might notice that I'm talking so much about Europe as if nothing happened elsewhere. There were similar such journeys that were beginning to happen in the East, but these churnings were not accompanied by any kind of a shift in the economic domain. Whereas in Europe, this was also the time when feudalism was breaking. I think those of you who are students of history or social sciences might understand, but it's important for students of law because the feudal culture is something that is inimical to what we call the constitutional scheme now. So you need to understand what is the other. And in all these changes, there was this whole churning and the coming together of such concepts called liberty, equality, and fraternity. The American War of Independence, the French Revolution, and much later, the Paris Commune, and in all these things, it was a very important shift, and the shift was sovereignty shifting from the king, that is the monarch, to the people. That the second important shift that accompanied this shift of sovereignty to the people was the people were no longer some kind of a collective mass or a herd of sheep. The people in this modern thinking that each one was an independent, isolated, at the same time part of a community. And which is where we have the origins of what we call human rights, that every human being has a right which is inseparable, indivisible from the self. In other words, each of us constitute the collective of units which have inseparable rights. And in that sense, we come to what is called the modern state. Modern state, which essentially then is republican. Now, all these were ideas that matured in Europe, and the thing about ideas is that you might erect a tall wall, You might erect barriers. You might ensure that people did not walk from this part to the other part. But ideas can never be prevented. There are two things that actually sort of any kind of invention by science and technology in human civilization has not been able to. One is the realm of ideas, and the second thing is atomic radiation. For instance, most of us would think that, every nation that has the atom bomb is a very powerful nation. No, I think, more importantly, every nation that has an atom bomb is also vulnerable, sitting on the edges of a disaster in itself. Chernobyl taught us the lesson, and it goes on and on, but, I'm not elaborating into it. But what is most important is the realm of ideas. Something that happened because of the British conquest or colonialism in India was that what we call Macaulay's minutes. Incidentally, Babington Macaulay is credited to the education policy of colonialism as well as drafting what until recently was called the Indian Penal Code. What is it now? Yes. The penal code, that there is this punishment for this offense kind of a thing, which again was something that brought in this concept of rule of the law, because in the Indian Penal Code and the Bharatiya Nyaya Samhita that we know, there isn't a different punishment for me because I happen to be a teacher, and a different punishment for you because you happen to be a student for committing the same crime. Of course, the name can be very different. If you take down from somebody who's sitting next to you in the answer paper, they'll call that it was copying. When I take it down the paper that I published from this paper, it's called plagiarism. But effectively, and some people can say that it is kleptomania, particularly if you are a rich kid, they'll say stealing, it's not stealing, it's kleptomania. But then effectively, all this is stealing somebody else's property. And the punishment has to be the same, and that is exactly what the Indian Penal Code is all about. Macaulay's education system at the same time, it came with a certain kind of an ideology that everything in terms of the knowledge systems in the East is all pretty much irrelevant, and what is necessary is exposure to knowledge systems of the West. The early resistance to it came by way of going to the West and coming back to say, and this is exactly where the roots of the Constitution of India should be traced. There's a very eventful year called 1905. I think students of history will call that the year of the partition of Bengal and the Swadeshi movement. 1905 was also the year when Japan defeated Russia, an Asian power defeated a European power in a battle. It was a very unequal battle. Nevertheless, the invincible advanced Europe was defeated by a sleepy Asia. And when this happened, there were several people from Asia who, for reasons out of their choice or otherwise, were living there somewhere in Europe. Gandhi was shuttling between South Africa and Europe. Nehru was more or less living in London. Netaji Subhash Chandra Bose. Talk about anybody, they were all somewhere there. And all of them as Asians went through this experience of initiation, which continues even today. That you are up on the ground, that knowledge cannot come to you, and you are not. And for all of them, the news of an Asian power defeating Europe was something that emboldened them. And when they all came back, they began to what we call talking back. There are two very important aspects of this talking back. By 1921, there was an archaeologist called Mortimer Wheeler who started digging down and found what is we all know as the Indus Valley civilization. And I'm sure most of you went to school. Am I right? I those of us who were living many, many hundred years ago knew how to channelize water without damaging. With building a tank might be a very easy proposition, but in many years, and it also boosted the confidence. In other words, there was what is called the discovery of India, and a whole lot of those who went and exposed themselves to these ideas of liberty, equality, started talking back saying, yes, we want liberty, equality. Now, why are you denying this to us? I mean, Europe was actually celebrating its own greatness by saying that we are a modern society, and denying all those things to the Asians, to the colonial, the colonial. And there was this whole talking back, and this talking back happened, and let me sort of touch a few important events where this talking back or the content of this talking back was reflected. I hope I am making sense. Or am I sort of, it's a bad time in the day to engage you in long conversation. So, in 1922, this was a time when the British had already given the Minto-Morley reforms, 1909, the Montecco-Chelmsford reforms. In all, they said that we are actually giving you training in a manner that I am trying to teach you something and give you something. That we are going to train you in the art of governing yourself. In 1922, that is when the Montecco-Chelmsford reforms was brought in, Gandhi actually wrote a piece in a journal that he was writing called the Young India. We don't want any of these things to be given to us as a practice and as some kind of a gift from a parliament. We are going to get into a modern constitutional scheme. He did not talk about the constitution in so many words, but that will be decided by the freely elected representatives of the people of India. It is not going to be coming from the Parliament of India. The House of Lords and the House of Commons have no business telling us how to rule ourselves. We will decide on how to rule ourselves. We will draft a constitution. We are not going to go back to the emperor. We are pretty much aware of it. But leave it to us. And since all of us cannot sit down and do, we will have a bunch of elected representatives of the voters to do this. And in the next 2 or 3 years, this idea gathered momentum. And even while it was gathering momentum, the colonial actually sent one of its own great men, called Viscount Simon, to see as to whether there can be an improvement in the constitutional reforms to train the Indians to govern themselves. And without actually waiting for even the formal announcement of the commission, the International Congress said they are going to boycott the commission. And not only said that they are going to boycott the commission, within a few months after that, they appointed a committee of their own set. It is otherwise called the Nehru Committee, headed by Motilal Nehru, to draft a constitution for India. And in this committee, there was this talk about fundamental rights. And in this talk about fundamental rights, there was this very clear understanding that there shall be a set of rights to the people, that every individual, including the right to carry arms, the right to free speech, and so on and so forth. And in addition to it, there shall be a mechanism to check, to ensure that these rights are not trampled upon. Something that I indicated in the morning, if somebody asked me what is the most important part of the constitutional understanding, bring jurisdiction. The Nehru Committee report was more or less of a consensus, and alongside this, there was another watershed moment, I would say, that was the International Congress session at Lahore, where they decided on 2 important things. They said, if this is not accepted, we are going to call ourselves an independent nation. And they even set the date as 26th January to be India's Independence Day. So when the Constitution came into force on the 26th of January 1950, it wasn't an arbitrary date. It was basically to sort of take from what was an audacious decision, so to say. The colonials were ruling, they were deciding what is the amount of tax to be paid to buy salt. Nevertheless, we said that we are celebrating Independence Day. And the celebrations went on. Indians were arrested, leaders were arrested, put in jail. There was then the salt march, it goes on. But in Lahore, they also took another important decision. And henceforward, we are not going to hold the International Congress sessions in the month of December. Normally, it was always held in the month of December. It doesn't matter to us sitting here. In fact, even November and December, it's a very oppressive idea to wear a jacket, and particularly for those of your students, to be wearing a jacket even when you're walking out in the hot sun. But in the northern part of India, it gets biting cold, and the Lahore session decided we should not do the session because we are no longer a bunch of coated, suited gentlemen. So those who constituted the Congress initially were newspaper owners, highly paid lawyers, and so on and so forth, who could actually go anywhere in India if it was cold, then they could wear the coat suit and the tie, and if it was warm, they could wear an appropriate clothing. But then the Congress now turned out to be an organization of the poor people. Whether they were wanted or not, whether they were delegates or not, they all came there. And the Congress records it. And now that the poor people who can't afford one clothing are coming to the Congress session, we cannot inflict this suffering. In a sense, there was this very important shift in the nature of the United Congress. Henceforth, we will hold the sessions in the month of March. The next session that was held was in Karachi, and in Karachi, there was a definition of what Swaraj is. That freedom shall mean freedom from want, freedom from oppression, freedom from various other forms of oppression, not just economic oppression. And in a sense, some of the fundamental, almost all the elements of the fundamental rights and the directive principles of state policy in our constitution were all declared as fundamental rights in the Karachi session of the sometimes you can actually go to and do a comparative study, and you'll find all of it coming in Part 3 and Part 4 of the Constitution. The reason why I'm actually sort of talking about it is it was not a momentous decision by either one person. So who wrote the Constitution? Who wrote the Constitution? Anyway, this is a version of the Constitution that Eastern Food Company published, and it is called a Code Fortification because easily and lawyers will be aware of it. Yeah, who wrote the Constitution? So it had how many authors? 7. Okay. When of late, we'll see academic papers in journals. And sometimes you find about 25 authors writing a 2-paragraph article. So, according to them, there were 7 authors. Who was the first author? There is also a concept of first author, and who are the others? Co-authors. And there is another oppressive mechanism in academia called Academic Performance Indicator (API), and the first author gets some points, and the corresponding authors or whatever it is, they get less. So who will you call the first author among the 7? Now this is where I think folklore continues to influence us, and the context that I had given, that where does the Constitution then emerge from? Probably from the break that was achieved in 1250 when the Lord stopped the king. Probably in the Cromwellian reforms. Probably the French Revolution when the people actually shouted liberty, equality, fraternity. And they also walked up the king, the oppressive king, to the guillotine, and also the queen in the it can probably be located in the kind of boldness that came among the Indians who were there in London and elsewhere in 1905 when they heard the news of an Asian power having defeated. But crystallized, all these things crystallized in the landmark events that I was talking about, 1922, 1927, 1929 and 1931. That all these things were put together as a set of rights that are inseparable and in a sense that are indivisible between each human being. Between each human being. In all these things, like the constitutional scheme had not evolved. And an approximation to what Gandhi said in 1922, that elected representatives of the people of India, I call it approximation because the people who elected the members to the Constituent Assembly, one of which it was not directly elected. The people, the minuscule of the population, 16% of the electorate, the 16% of the adult population, elected members to the legislative assemblies under the Government of India Act 1935, who in turn elected members to the Constituent Assembly. But a very, very crucial intervention happened here between the time that the members of the Legislative Assembly were elected and between the time they sent their representatives to the Constituent Assembly. There was a very clear political intervention that said, we are not going to treat this election as electing a body to rule us. Instead, we are going to elect people who can draft a constitution for independent India. In other words, there were people who did not form part of the freedom struggle. When you look at Motilal Nehru, he goes to form his own party, gets into representation, but comes out and so on and so forth. The people like M.R. Jayakar, who did not want to be part of the freedom struggle. There was somebody like Shyama Prasad Mukherjee, who did not really join any of the struggles, but had by the time been influenced by an idea of another kind of a nationalism. And a host of other people who did not even walk anywhere when there was a protest taking place. It was ensured that those people, with all their legal prowess, their knowledge and so on and so forth, should also be part of the assembly. So even if they were not members of any of the political organizations that fought for the struggle for independence, they were all brought into this Constituent Assembly. And I think those of us sitting here can actually take pride in the fact that a large such number came from the Madras presidency. Legal luminaries, writers, scholars, a journalist called Shiva Rao, were all taken into the Constituent Assembly not because they went to jail. In fact, the number of people were such who had not even seen the inside of the jail. It came up in the Constituent Assembly. I'll come to that point a little later. When they assembled, there was still this doubt. It's not directly elected. So are we the ones who should actually draft the constitution for independent India? Should we not have an election before we start writing the constitution? Now this was a situation that they encountered. He said we need to have an independent election, which can be called a free and fair election. What we need is an independent election commission. And an independent election commission has to be constituted and created by the constitution. It has to be a constitutional body. So you need a constitution in order to ensure, otherwise any kind of an election commission that we appoint can be a subservient election commission. It won't be a constitutional body. So you need a constitution even before you can actually have that idea. And it was in all this context, somebody like K.M. Munshi comes out with clarity on this, that the Constituent Assembly started work. The next important stage of the Constituent Assembly was what is called the Objectives Resolution. The first business that was carried out in the Constituent Assembly on December 1946. And if you read through the Objectives Resolution, particularly paragraph 5 and 6 of the Objectives Resolution, can somebody, 5 and 6 of the Objectives Resolution, 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 5 and 6 of the Objectives think in terms of doing an exercise, I mean, not immediately, but you can do it yourself and decide, judge whether I actually spoke the truth or not. If you read through paragraph 5 and 6 of the Objectives Resolution, and you read through the fundamental rights as enshrined in the Constitution, and also the preamble to the Constitution, you find everything that is there in the preamble as well as the fundamental rights concise there in paragraph 5 and 6 of the Objectives Resolution. Of course, there were others who actually talked about it. For instance, is anyone, I mean, I'm sure some of you are familiar with VIT. What is Republic Day in VIT? Ganatantra Divas. What is the second word of the national anthem? Tagore wrote this in 1911 that India is going to be a republic. Ganatantra, Jana Gana Mana, Adinayaka Jaya. That the people as a republic, as supreme. So there was this idea that was there, which gets concretized in the Constituent Assembly. And it was for nothing else that, Tagore saw. Incidentally, we knew what Tagore had to say about nation and nationalism. You'll get shocked. In fact, Tagore was invited by Japan after they defeated Russia to speak in a hall. And he went there, he took their invitation, he went there and said, let me tell you very honestly, you people are on a disastrous path. Your love for the nation, nationalism that you're building is going to lead you to a disaster. And what Tagore said in 1905 to the Japanese, who had invited him for a lecture, he was never invited again. Came through some 40 years later, 1945, exactly, when the kind of a nationalism that Japan built over supremacy and ideas, leading to its attempt to colonize the rest of Asia, led to its own disaster in Hiroshima and Nagasaki. So in a sense, Tagore had his own different views on national nationalism, but he had this whole thing that the government in future should be one of the people, where the people are the sovereign. And this he wrote in 1911. And all these actually came into the Constituent Assembly, and they took at least 8 more months, and a lot of things happened inside the Constituent Assembly before the 29th of August. What is August 29 significant for? August 29, 1947. Any idea? Okay, you're all first year students, so I don't. The drafting committee was set up on the 29th of August 1947. That is the first author, according to you, and the 6 others were appointed as authors by a large body of men on the 29th of August 1947. And a lot of things transpired, and one such thing that transpired was Dr. Ambedkar actually contested elections as the Indian Labour Party candidate from Bombay, but unfortunately he was defeated. He played into the hands of Muhammad Ali Jinnah, went to a place called Jesur Bulga in East Bengal to contest election from there, and he comes into the Constituent Assembly. And when Nehru is presenting the Objectives Resolution, he tells Nehru that all that you have talked is wishy-washy, there is nothing. What is the guarantee? What is the guarantee that if all these rights that you're guaranteeing to the people in Republic India are going to be trampled upon? So all these rights that you're talking about will have no meaning unless you have a mechanism which ensures these rights. He was talking about the rate jurisdiction. He says this in the debate. And suddenly, when Cyril Radcliffe, an Englishman, sent to India to draw the map as to what will go to Pakistan and what. When he landed in Delhi, it was July, and Delhi is a very bad place in July, even then. Delhi is very bad in any time of the year now. I mean, there's something that I tell my students of history. There are 2 lessons that history teaches us. Never invade Russia in winters. Napoleon did it, Hitler did it, But I mean, there were other factors. But then the second lesson is never invade Afghanistan any time of the year. Russia did it, it got beaten and I mean led to its own collapse. America did it, it thought that like Osama bin Laden being killed is going to end terrorism, but in the process, its own economy, so much so that Uncle Trump is now scared of letting us get HPA1 visa. What is it? That I always get confused with this thing. There is another HPA1C. I mean, those of us who are detected diabetic are now told to go for it once in 3 months, the average blood sugar doesn't all. So I get confused with Trump and diabetes. Yeah. So they're scared even now because one of it is like, the whole effort to keep the dollar high based on armaments and wars, it came down. And now, there is what is called the crisis. Anyway, in this period, Jasur Kulna, Radcliffe came to India, July is very bad, and the Sahib could not actually stand the heat and the moist heat. Seemingly, he developed diarrhea and dysentery. He got scared, did not step out anywhere. He sat down inside a room and drew the map that this shall be India and this shall be Pakistan, based on some kind of figures. And as a consequence, Jasur Kulna went to Pakistan. And since Jasur Kulna went to Pakistan, those who got elected to the Bengal Assembly from Jasur Kulna, Dr. B.R. Ambedkar, was no longer a member of the Constituent Assembly. Rajendra Prasad, on instructions from Gandhi, intervenes to make sure that a seat was vacated in Bombay, and Ambedkar comes to the Constituent Assembly. So it was, I mean, there was a lot of politics, calculations, so on and so forth, that on 29th of August, there's a drafting committee with the chief author or the main author appointed in such a capacity. But once this was done and it was necessary, even in the terms of reference, that there shall be a set of fundamental rights. So even before August 29, there was something called the Fundamental Rights Subcommittee of the Constituent Assembly, who drafted what shall be the fundamental rights of the citizens of India, the right to free speech and so on and so forth. And it took a long process, and in the end, I mean, the fundamental rights of the Constitution, when does it start? Article 12 defines what fundamental rights. 13. What is the most substantive article then after 13? After 13, it is 14, right? And surely, I mean, your hatred to mathematics did not prevent you from getting that knowledge. I'm presuming that all of us hate maths. Is there anyone who loves maths? Okay, you should not hate maths. Mathematics helps a lawyer very much. Okay. Article 14, it talks about the right to equality, irrespective of caste, religion, so on and so forth. In all the fundamental rights that we talked about from Nehru Committee report to Karachi and all, the priority was for freedom of speech. The right to free speech was on top of the list of fundamental rights. By the time the drafting committee or the fundamental rights subcommittee looks at it, it actually comes to this whole conclusion. Look, the right to free speech has no meaning unless you have the right to equality. Equality, more particularly the social sense of the term. I mean, let's not forget, let's always keep in mind a story that we have all heard probably from the Mahabharata, the story of Ekalavya. Ekalavya goes to Professor Drona, asking him that you all came to the school of law, asking to be imparted education in law. Likewise, they went to Professor Drona, and Drona said, no, I cannot admit you, not because you are not meritorious, on the contrary, you belong to a caste that should not be fighting. Ekalavya, however, constructed a statue of Drona, it seems, And I mean, I think, 6 or 7 years ago, I would have simply laughed at it. How can you learn something from the statue of somebody? But after 2020-21, I don't really write it off. Where did we learn in 2020-21? Logged in and went out. Right? So it is possible for a statue to teach you something. Anyway, that is how the story goes. All because, and so the access to knowledge. Of course, there is something very idiotic about this story. Eklavya belonged to a caste or a community that is otherwise called the Nishad. The Nishads are people who otherwise are also hunter-gatherers. So isn't it ridiculous that, hunter-gatherer, the child born in a, like for instance, who becomes a successful lawyer? Anybody, someone just tell me who becomes a successful lawyer? A successful lawyer's son or daughter. There are exceptions. Who becomes a successful minister? Successful minister, son or daughter. Very rarely daughter, but most often sons. It happens everywhere. Though in modern society it should not happen. There's mobility and coming back to the story, the makers of the constitution, particularly those in the Fundamental Rights Subcommittee, resolved that look, we cannot talk about equality, freedom, and so on and so forth without actually addressing to this question of differences based on caste that are imposed on the people. That one set of people are told that you should not touch me, and if you touch me, or if I touch you, you will be punished. There's something wrong with it. That's where we have 14, 15, 16 and 17. Of course 15 and 17 came later in the course of the discussion in the Constituent Assembly. So the authors are not really 7 people, but all those others who were there in the Constituent Assembly. Okay? They borrowed from them. And they never claimed that it is our constitution, by the way. And the constitution, as it read, was we the people of India. So there's no author. Aditya Nigam, the political science scholar, has written a beautiful article from the books. And the constitution is a text without an author. It's a text without an author. The authorship of the text then comes from this legacy, and more importantly, not only the legacy of the freedom struggle, but a very clear understanding of the reality of the society over the years. That it is a caste-ridden, unequal society, and unless you actually eradicate this inequality, you cannot talk in terms of freedom to speak and express and so on and so forth. So in a sense, there was a very important kind of distinction. I'm just saying it, sort of learn more about this in the course of your next 4 years legal education. Due process of law. Somebody can just write it down and try to sort of tease yourself and otherwise. Due process of law or procedure established by law. Sometimes, when you feel like you can start looking into it, it's a very important difference. It is not just about semantics. It is something more deeper. In all the drafts in the Constitution, the right to life, which is there in Article 21, it was said that everybody has the right to life and liberty, and it cannot be taken away without the due process of law. Which means, if I am going to be arrested, the implication of me being arrested could be until I am proven guilty, I will lose my livelihood because my university is not going to allow me to take online classes from jail. Right? So my right to livelihood is affected in the process. My right to come and talk to you, that is by free movement, is affected and so on and so forth. So the law should actually, there should be a decision or an assessment as to whether the arrest, even if it was warranted, whether the implications of this will lead to further curtailment of more fundamental rights or not, and the court to decide in that process. This is what the American jurisprudence and what Professor Venkat Rao was telling. The third thing that the judge said, the Constitution is what the Constitution is according to the judge. There is a Constitution, but even the Constitution at every point of time is what the judge decides on it. This is the due process of law. So at any point of time, there has to be an interrogation as to the effect of it. Procedure established by law is just that, like if a law is there that you can be arrested, and Professor Rao also touched upon, the Honorable Judge actually touched upon Article 22 of the Constitution. Article 22 of the Constitution, incidentally, was not there in the original draft. It comes into the Constitution much late, which allows for a very good, and when they changed this whole thing from due process to procedure established, there was a lot of resistance inside the Constituent Assembly. And in addition, they came with an argument that the reasons for your arrest has to be communicated to you, which was already there in the Criminal Procedure Code. What is it now? Criminal Procedure Code? Okay, something, okay. I mean, everything has a Bharatiya card to it. Yeah. This constitutional provision allowed for what we call preventive detention laws. That somebody can be arrested and kept in jail for any number of days, provided there is apprehension that this fellow can create trouble. It was not there in the original draft. It was brought in as a later insertion into the Constituent Assembly, and that is when a few members actually told Mr. Chairman of the Drafting Committee, the tragedy is you never saw the inside of a jail all your life. So Ambedkar responded, I will try to experience that henceforth. Look, somebody like, who stayed away from it is now talking about joining the Republic and becoming an integral part of it. This is also what the constitution making process achieved. Then the other members stood up and said, the constitution or this provision that you have today introduced in the assembly will ensure that you will go to jail. And it was opposed, and this is exactly what I referred to when I talked about the case involving Rajan. The right against detention without any reason except that, I think your being around is going to create a problem. I mean, all those who were picked up and detained during the emergency, except a few people who were involved in the Baroda Dynamite conspiracy. Some of them spent 19 months in jail. When they came out of the jail, they realized there was absolutely no charge sheet against them, nothing against them. It was mere apprehension that they were in jail. I know of somebody who was working with All India Radio, was taken in, kept in jail for 19 months. When he walked out, he could walk back to his office and say, I'm joining. And there was no case against him, so his job had to be kept intact. Of course, there were others who were killed in the process. But yeah, those were killed. So there were these dark spots that also came into the constitution. And a lot of these dark spots were also rectified by way of amendments. Professor Rao talked about the 16 days that shook the world by Prabhudaman Singh. Where the first amendment, he refers to only one particular amendment to Article 19(1)(a). But the first amendment was far more significant for two other insertions into the Constitution. One, Article 15 and 16, particularly Article 15, there was a new clause added to Article 15, that is 15(4), that is, reservation in educational institutions shall not be unconstitutional. That followed a case from the Madras High Court, Champakam Dorerajan versus State of Madras, and went to the Supreme Court and it clearly said that you can have reservation in government jobs but not in education institution because the constitution does not provide. So if I actually accept the fact that the first author of the constitution is who he said was, unfortunately it was a constitution that did not provide for reservation for the scheduled castes. It had to be rectified. The first amendment was also that. In the 16 days, they did not actually do only with freedom of expression. They actually created a provision which allowed for reservation. There was another leg to the first amendment that zamindari abolition was considered to be an article of faith for the freedom struggle. And legislations abolishing zamindari were challenged in the Patna High Court by someone called Kameshwar Singh, who incidentally was a member of the Constituent Assembly, saying that his right to property, which is a fundamental right, Article 31, is now being violated because his land. And don't think like, he had a small house with some kitchen garden there. He had 5,000 acres of land. And he resisted. He said the Constitution gives me the guarantee to right to property. The First Amendment said, any such legislations, if it is put in Article 31B, there is a 9th schedule. We had 7 schedules, then several languages were added. Something very important. There were 7 schedules to the draft constitution until the time that it came for adoption. And at the time, that is in September 1949, there was this obvious question, okay fine, what is the language? What is the national language? So a bunch of people shouted, obviously Hindi. Then another set of people in the assembly said, no, it cannot be Hindi. I don't speak Hindi. He happened to be a Bengali. And incidentally, Shama Prasad Mukherjee was the founding father of the present day government, the party in power. He said, no, I don't speak Hindi. It cannot be the national language. Because he was a Bengali. There were people from Madras, there were people from Andhra who had said, no, it cannot be Hindi. And there was a committee appointed. Ananth and K. Munshi got together and they hammered it out by saying that there shall be a set of 14 languages which will be added to the 8th schedule. There will be new schedule and the 8th schedule, and all these languages will be at par. So Hindi, Telugu, Tamil, Marathi are all at par. Even today what we have is an official language. But most often we have been told again and again that Hindi is a national language. I mean, those of us studying law must be very conscious and aware of it. So it was basically an effort that put into a lot of inputs which came from not only inside the assembly, from outside the assembly also, by various newspaper articles and so on and so forth, rooted in a tradition that is called the struggle for independence, and a certain idea of India that emerged there, where India is going to be a nation where people are guaranteed equality irrespective of caste and creed and so on and so forth. And the constitution became a statement, also a tool to ensure this idea of India, a tool, a mechanism to ensure this idea of India. So as Leonard Chet was talking about in the morning and Professor Rao was telling, if you are going to look at it as a text to write your examination and get good grades, then it's very difficult for you to remain a good lawyer. If you are going to look at it as an instrument, as something that is a window to understand India as it was, and then to sort of look at what surrounds you and see how much has changed and how much it should change. And what I told you is, with a determination not to leave the world as it was when I came in, then you will look at the Constitution as a tool to achieve something of a better world. And lawyers, it's not just the job of a salesman that you have decided to opt for. It's a calling. In fact, there are a lot of things, let's say on the advocate's code and ethics and so on and so forth, most often followed in defiance. I mean, I'm sure you all must have seen a small pouch hanging behind in the back of the gown. What do you think the pouch is for?
Carry money.
Huh? Carry money. Not to carry money. The lawyer is not supposed to take money. On the contrary, if you still feel happy, you might actually drop a few shillings, and that's why it's behind. But the lawyers don't carry money. I mean, they don't carry money. And money is carried somewhere else. Now, a lot of these are followed in defiance. But there is something that you always keep in mind. I mean, Ratlam Municipal Corporation versus State of Madhya Pradesh, which led to what we call the public interest litigation on set. And the Noida land acquisition case, and a whole lot of cases, whole lot of instances where justice reached common people. Article 21 says the right to life is not mere animal existence, it is the right to livelihood. Olga Tellis versus Bombay Municipal Corporation. It was all made possible by a set of lawyers to whom law was not just another job to do, that of a salesman, but it was a calling that men who actually looked at the Constitution not as a text. I mean, with due apologies, the only example that anybody talks about in constitutional law is Nani Palkiwala. But with due apologies, Palkiwala did not speak for the common man or the ordinary man or the poor man. On the contrary, Palkiwala spoke only for the property classes in this country. In Keshavananda Bharati, he argued for the mutt head who challenged acquisition of large tracts of land that was there exploited by the mutt. Palkiwala appeared for them. I mean, but at another level, let me also say that of all the cases that Palkiwala appeared, he lost most of them. And that is what the Constitution has ensured. There are aberrations. There are instances when the property classes abuse the Constitution to the hilt. But then, that is because want of wonderful lawyers, public-spirited lawyers. And this is a profession that actually enables you to do things more than what those of us who are in the teaching profession can do. So, wishing you all the best, but looking forward to questions and answer. I mean, I'm open to any kind of a question, any kind of criticism, even if it throws stones, I'll be very happy about it. Okay, if you still have questions, you can probably send me an email.
Professor, I have a.
Yeah.
So, we got this due process and then the other one, the law.
Procedure establishment.
Yeah, procedure establishment law. Just wondering, would you like to reflect on, I mean, it would be great if you could reflect on this, the current controversy on appointment of judgments, drawing from these ideas actually. I mean, it's a judiciary versus legislative debate, right? So, like, who should have the power, in terms of appointing judges and all that. So, is this the kind of meritorious, or since the power comes from the people, and then we are the representative of the people, therefore we have the power to appoint the judges. But whereas the judiciary says something else. So, I mean, because you touched upon this, I think it would be really nice, helpful to all the students and then people like me to say something on that. Thank you so much.
In fact, this has been an area where the courts have had the opportunity to decide on their own sense. I mean, the judges' appointment case, there are 3, 1, 2, 3. And in all these things, the judges sat on judgment on how they should be appointed. The other argument being there should be something called a judicial appointment committee. I mean, there should be a panel and all. I think, there is merit and demerit in both the sides. With the judges appointing themselves, and most often it is in so much of secrecy as to what goes on, and even recently, we all know that there's a certain judge who gave a note of dissent in the collegium. Nevertheless, we don't know what the dissent is. I mean, judges at one level who wax eloquent on the need for transparency, which is very important in democracy, nevertheless refuse to be transparent themselves. Now, having said that, I would want to sort of go back to what Dr. Ambedkar said in the last stages of the Constitution, finally when the Constitution was adopted. He said, what we have been able to put together and what we have adopted is perhaps an excellent contradiction, but not one without pitfalls. In fact, the draft constitution and the way it was adopted, it had Article 379, which said that until the elected parliament comes into place, when Article 368 and the amending process will be played, until such time, which means it can be 6 months, 1 year, whatever it is, the Constituent Assembly will function as provisional parliament and can carry out amendments. Incidentally, the first amendment was carried out by the Constituent Assembly before the first general elections. 3 very important principles were brought in before the first parliament came into place. But while putting out all these things, Ambedkar said one thing. We have had the finest of the Constitution. Of course, there are pitfalls and we have provided scope for amendment at any point of time. And even after this, if something fails, if something doesn't work, it is not because the Constitution is bad, because the men who work the Constitution are vile. He used the word vile, V-I-L-E. I mean, can somebody check the meaning of V-I-L-E, vile? Morally bad, repugnant. I mean, you can't handle an excellent constitution to a bunch of people who are repugnant, who have absolutely no sense of morality, and expect the constitution to work. And I think, insofar as the judge's appointment is also concerned, the same process had given us such judges like O. Chinnappa Reddy, had given us V.R. Krishna, about whom Professor Rao talked eloquently, and given us Gajendra Bedkar, and given us a lot of such people. And the same process have also given us judges who, instead of reading the law and deciding on the basis of the law, even sort of, have no compunctions confessing in an interview. And I prayed to God before I wrote the judgment. And I hope all of you know who I am referring to. Did not look at the constitution on which he swore his allegiance. Did not look at the law, because the dispute was one of property between the two people. Did not look at any of these things, but asked God to. But did not have the courage to put his name to the judgment. This was perhaps the only judgment in India's history, legal history, where, like the constitution, a text without an author, there is one judgment without an author. All of them agreed. And the agreement was so reflected in the Chinese restaurant at Taj Mansingh in Delhi. When instead of holding hands like this, they were holding hands like this. And he said that, it's God's own decision. We have all these. We have had Chinnappa Reddy, who even after delivering some of the excellent judgments says, no, there are a lot of gaps in the Supreme Court's history. It is justice incomplete. We have this thing. So I think, the system consists of the written word, the spirit, and the men behind the word. So the problems, particularly with the judiciary, and when I started, I said, it's pastoral. The judges belong to this community of, they stand on a pedestal. I would still say that, 75% of the higher judiciary is clean. I'm not telling the other thing because, when somebody said that, it turned out to be a content. 75% is wiki claim. I'm not talking about the 25%, but that is itself a bad omen because an incorruptible judiciary, a fearless judiciary is something that is signed to a nod insofar as the rule of law is concerned. It's a serious problem. I think, there's no answer to which of the two is correct. That's my.
Just to take this, what you were saying forward. Just to take what you were saying forward. First one was what we were talking. First, what you were talking, or what the other judge also talked about is what the judge decides on that day, or what the judge thinks at that point is the constitution. And now we also know about different types of judges who are prevalent, which would be it would make the whole constitution itself shaky, keeping the vile repugnant in. Did the framers of constitution think about this when they were writing it, or when they were saying about how to? Can you please just throw some light?
Yeah, in fact, this aspect was intensely discussed right at the Fundamental Rights Subcommittee, then in the Advisory Committee. And Aladi Krishna here keeps clarifying, look, if we are going to use the due process of law, there is this danger of judges turning this way and that way. There won't be stability. And if we are talking about procedure established by law, there's absolute stability. And he adds, keeping this danger in mind, I am for taking the risk. There are examples from American jurisprudence, American judgments, where the judges go in for pro-poor legislations and then sort of strike them down and so on and so forth. He says, nevertheless, despite the uncertainty involved, I am for the due process. Then there is this question that arises. Look, we want to abolish zamindari. So there is the possibility of, and the person who raises this is Sardar Vallabhbhai Patel inside the advisory committee. We want to abolish zamindari, but when we do that, there is the possibility that a certain judge is pro-zamindari and he overturns the legislation. So I don't want this uncertainty. There is no compromise insofar as abolishing zamindari is concerned. Govind Vallabh Pant says this. And Dr. Ambedkar joins a solution that was broached by K.M. Panikkar in the subcommittee to say, let us take right to property into a separate article and right to life be kept separately. And insofar as right to life is concerned, let us insist on due process. Let right to property be guided by procedure established by law. So, there's a compromise. And the committee agrees to this. Advisory committee agrees to this. It's put before the Constituent Assembly. But somehow when it comes to the drafting committee and in the last stage, when the draft constitution is introduced, due process is replaced with procedure established. And that's when there is one more debate. Voting on that particular clause is postponed because there is no consensus. Not that there was no consensus, but voting was postponed because they feared that there were more members in the Constituent Assembly who cared for freedom rather than regimentation. The one who now pushed against due process was C. Rajagopalachari. So, it was intensely debated. Perhaps I would say that among those provisions in the Constitution that were most intensely debated, not on a day but on days together, or days on end, at every stage of the Constitution making process. Not once. And finally, when they say let it be procedure established by law, is when H.V. Kamath, he says, you haven't experienced the inside of a jail, Mr. Chairman. So, I think, and to me, the judiciary actually shifted to due process beginning to an extent in Keshavananda Bharati. In fact, in Keshavananda Bharati, while the judges did not really specify that this is the basic structure, each one of them listed certain things. But it can be like this, it can be like this. But the judgment. But there was one judge who made this very pointed reference, H.R. Khanna. He made a very pointed referencing. I'm not going to say what is basic structure, but I'm going to say one thing: right to property is not basic structure. Hidayatullah, even before that, said, I don't know why it is there in the fundamental rights, it should not be there. Which finally leads to the 44th Amendment deleting Article 31 completely. Right to property is not a fundamental right. But at the same time, there are these grey areas which were left for another set of judges. So in some sense, yes, the concerns that were raised inside the Constituent Assembly, much later, like Article 22, in the A.K. Gopalan case, there is a dissenting judge, Fasiladi, who says, no, I mean, preventive detention is obnoxious. It should not be there. But it is there in Article 22, so it is not unconstitutional. Ideally, it should not be there, but since the Constitution provides for it, I am leaving it there. And he also indicates, I hope someday this anomaly will be corrected. Now, by the time you come to the right to property, that is R.C. Cooper, when the bank nationalization case came, the implication of the law was read by the judges, particularly Justice J.C. Shah, to say that by denying the shareholders the right to do any business, because the bank acquisition said, we cannot allow you to continue the banking business. You have expertise there. You will once again do the same things. So while your assets are taken over, you have no right to continue the banking business. You should do any other business, not banking. The judges, by implication, say this is what you call treading upon the right to profession as guaranteed by 19G. So, Bank Nationalization Act was struck down on that basis. In other words, the effect of the legislation was factored in to strike it down, which is what due process is. In Maneka Gandhi, this gets confirmed. So, due process jurisprudence takes over by 1980s. I think the whole lot of judgments that have been talked about from the morning, all that is right to life is not mere animal existence. See, the Bombay Municipal Corporation has a law that anybody who puts up a shelter on the roadside has no business, they're squatters, obviously they should be evicted. But in all that, evict them, but not before giving them an alternate dwelling. Because the right to life is not mere animal existence, it is the right to livelihood. Expanding it. That is because this eviction, according to the judiciary then, would lead to the right to livelihood being taken away. That is the impact of the law as it is. So the law as such is not bad, but its implications or its impact will be bad. So we are not allowing you to do that. Due process legislation. I can multiply this bonded labor case and so on and so forth. But there have been instances when the judiciary has taken this shift from procedure established, which is what the Constitution says, to the due process jurisprudence. So it has been I would say that it has not been so bad, the experience. On the whole, I think a little more good has come to the Republic and the people of India due to the shift to due process. I think I'm done with.
Good afternoon. My name is Somjiva. Today we are here to discuss about 75 years of Constitution and the legacy of the Constitution. And also we are discussing about the basic structure of the Constitution also. Did really basic structure protects the legacy of the Constitution till now, sir? Basic structure of the Constitution protects our legacy of 75 years of Constitution?
I think yes. I think, but for the basic structure doctrine, the Constitution would have been defaced by now. The basic structure doctrine prevented a large part of the kind of amendments that Indira Gandhi wanted to bring to the Constitution, including a new article to the Constitution that said the election of the Prime Minister, President, Speaker and Deputy Speaker, Chairman of the Rajya Sabha should not be questioned in any court. There should be a separate tribunal. It said like, I mean, Article 14, right, equality, and even Justice Chandrachud declared that unconstitutional. In fact, one particular constitutional amendment that was declared unconstitutional due to the basic structure doctrine was this particular amendment. So in some sense, I would say that parliamentary supremacy again was flagged off as part of the basic structure. I mean, we always have this fascination for a strong leader. Plato is not dead. Plato probably died long ago, but he is not yet dead. I mean, this fascination for great leaders, strong leaders, and what is a strong leader? It varies. A strong leader is somebody who builds a great park. A strong leader is somebody who gets metro rail to my city. A strong leader is somebody
3,000 feet of statue.
Huh?
3,000 or 5,000 feet.
A strong leader is somebody. What is this? What is this? What do you call something that is applied here? So I'm not telling who a strong leader is. Huh? Yeah. So there is still this fascination for strong leaders, and there is also something that has come into our thing through cinema. Who is the cause for all the problem in our society? In my own state, there is now one person, after doing some roles, is now wanting to liberate the people of Tamil Nadu, and the people of Tamil Nadu are willing to go with their infant children, get killed in the stampede, because he's come to liberate us. Through cinema, we have been told that politicians are a dirty bunch of people. And what do the politicians do? They become MLAs, MPs. So what is Parliament doing? They are destroying us. So what we want is a strong leader. It can be a general. I mean, I think you're not familiar if you watch television, particularly Arnab Goswami's channel. You know somebody who has a mooch that covers most of his face. I mean, I know him as a moochwala, a mustache. Some retired army general screams and screams and screams. I mean, as if leave him and India is going to become. I mean, he is another Alexander the Great. He'll capture the rest of the world. So, basic structure doctrine has actually saved us. Because a constitutional amendment of that kind, hopefully, will still be struck down by the Supreme Court. Hopefully, depending on the spine that judges show. But these are all things that we need to keep on cultivating. Democracy is not something that is handed over a platter. The Constitution again is an instrument. I mean, just because, honestly, waiving the Constitution is not going to make any difference. Using it is going to make a difference. I hope you understood. I answered a little bit of your question. My purpose here is not to give you yes and no answer as much as whether the sun rises in the east or anything else. In school, if you had written that it is false, you would have been given a wrong mark, right? So, but the idea is to confuse you a little more. You're all in your first year. Okay? I think there are others also. Next session. Shall I go?
Thank you, sir, for your valuable time. This session on Constitution and its legacy was truly inspiring, and we extend our heartfelt gratitude to sir for sharing his profound insights in Constitution's making and its legacy. Your thoughtful reflections on how our Constitution's history and its legacy is formed has given us a renewed appreciation of our founding leaders' monumental work and responsibilities moving forward. We are grateful for your clarity, scholarship, and passion in helping us understand the Constitution's history and legacy in a very different perspective, and also the historical and philosophical references that you have given are so captivating. Thank you, sir.
Respected dignitaries of the dais, a very pleasant evening. Myself, K. Omkar. I am currently pursuing first year BA LLB degree in this esteemed law school. Today, for this session, our guest is Dr. Sambaya Gundimeda, sir. Dr. Sambaya Gundimeda, sir, Associate Professor of Politics at VIT University, Andhra Pradesh. He is a distinguished scholar of Indian politics with a particular focus on caste, religion and power. He hails from the village of Gundimeda in the Guntur district of Andhra Pradesh. Dr. Gundimeda completed his BA in Special English, Political Science and History from Andhra College, Vijayawada, followed by an MA and MPhil in Political Science from the University of Hyderabad. He was awarded the Ford Foundation International Fellowship to pursue his PhD at the School of Oriental and African Studies SOAS, University of London. Early in his career, Dr. Gunimeda sir joined the Council for Social Development, Hyderabad as an assistant professor. He has held prestigious fellowships, including the Charles Wallace India Trust Visiting Fellowship at IASH, University of Edinburgh in 2013. Visiting Associate Fellowship at the Center for the Study of Developing Societies (CSDS), New Delhi, 2014, and a fellowship at the Nehru Memorial Museum and Library, New Delhi, since 2015 to 17. Before joining VIT University, he served for 10 years at Azim Premji University, Bengaluru. Dr. Gunimera's research engages deeply with Indian politics, focusing on Dalit mobilizations, social equality and democracy. His seminal book, Dalit Politics in Contemporary India, published by Routledge, draws an archival research, fieldwork and case studies to examine the emergence and evolution of Dalit political consciousness across India. In addition to his work on caste and political power, Dr. Gundimeda has studied the evolving role of the cow in Indian political mobilization, exploring the tensions between religious sentiments and the rights of minority communities. He is also deeply interested in the Constitution of India, particularly its framework for inclusivity and diversity, and is currently working on a project engaging with the Constituent Assembly debates. Dr. Gundimeda combines rigorous empirical research with a nuanced understanding of political theory, offering critical insights into contemporary Indian democracy, social justice, and the dynamics of the power in society. I hereby welcome Dr. Gundimeda to the dais, and the start will come in 5 minutes. The speech will be started in 5 minutes.
Guys, thank you very much for being here. I know it's too late, but still. Thank you, Professor. Thank you, Professor Banerjee and his colleague, for giving me this opportunity. Actually, I won't kind of take much of your time. I will straight away get into this topic. But before that, I just wanted to say something that it's during our time, and now don't think that I'm kind of telling you like a parent. I mean that's true in a way. I also have a daughter and then son. Whenever I talk about like my childhood, and then they'll say, Nana, you stop talking about your childhood. We got it. You are from a village, and you didn't have a school in your village. You had to travel a little quite far. We got that. You don't have to kind of say it again and again. So when we say something like this, you also kind of probably might think that way. But the point is, when we were doing degree, we didn't have this kind of opportunity like seminars, workshops, like the way you sort of learn and then meet experts, get inspired, and then do something around those lines and all that. But it's so nice to kind of have these kind of seminars. I sincerely urge all of you to take advantage of these. Thank you. So my topic, I'm sure like some of you are familiarized with this topic. I'll just read out this title: The Uniform Civil Code and the Constitutional Morality of Pluralism, from the Constituent Assembly debates to the Uttarakhand experiment. So what I'm planning in this talk, I don't know how much time I will have exactly, but it's kind of two or three quotes in the sense I just wanted to trace the whole issue historically, and then Constituent Assembly debates, then followed by that how the judiciary actually touched upon this aspect, then the now I want to do this precisely because for a lot of people, history starts with from 2014 onwards. Yeah, for a lot of people actually. But I want to kind of take you back a little bit further where it all started and all, so that we will have this larger overview, how we arrived at, and then what to kind of take forward, or how do we sort of take forward beyond this. So my talk traces this constitutional trajectory of this Uniform Civil Code from the Constituent Assembly's moral deliberations and the Supreme Court's transformative intervention to the legislative experiment of the Uttarakhand Civil Code. It asks how constitutional morality can reconcile the egalitarian promise of the Article 44 with the pluralist structure of the Indian personal laws. Then the talk demonstrates how judicial interpretations of Article 44 have redefined the relationship between personal law, individual rights, and constitutional morality. So now it argues that the recent legislative development risks converting a liberal project of reform into an instrument of majoritarian uniformity. And I conclude that a genuine democratic UCC must be dialogical. Search point. Plato still lives. Dialogical and plural, anchored not in coercive homogenization, but in deliberative constitutionalism and the moral discipline of persuasion enunciated by Dr. B.R. Ambedkar's concept of constitutional morality. So as I said, let me take you back a little bit kind of pre-independent India. So the landscape of pre-colonial India was characterized by pervasive pluralism across both Hindu and Muslim Islamic traditions. Law did not emanate from a singular authority, but emerged from a mosaic of scriptural texts, customary norms, and decentralized adjudicatory practices. Hindu law functioned as a layered and regionally differentiated system grounded in Shastra, scriptural jurisprudence, Achara, customs, right? Even still we follow, and the interpretative glosses of jurists. Foundational texts such as Dharma Shastra, as Patrick observes, were pedagogical in nature, didactic guides rather than enforceable legal codes whose authority derived from their local acceptance. I think we should really understand it. It's not kind of universality, although people follow, people draw from these Dharmashastra ideology, but actually it's from the local, regional acharas. So the way they interpret locally, kind of panchayats. Doctrinal diversity further emerged from through regional commentators like Mitakshara, a gloss on the Yajnavalika Smriti by Vignaneshwara, and Dayabhaga by Jimuta Vahana, that introduced distinct principles of inheritance and succession, shaping divergent schools of Hindu laws across different regions of the subcontinent. Legal authority in the system was highly diffuse. As Vernon Mensky notes, adjudication was conducted by Brahminical jurists, caste panchayats, and kin-based councils, all of whom drew on plural repertoire of textual and customary sources. This vernacular jurisprudence prioritized contextual resolution over uniform codifications. Even under Islamic rule, Hindu personal law was administered by Hindu interpreters, and customary norms often prevailed in matters such as property and family law. Islamic law too functioned as a plural and a dialogical tradition rooted in the Quran and the Sunnah. Classical jurisprudence evolved through interpretative mechanisms such as isma, consensus, and qiyas, analogy, resulting in diversity of legal schools, Madhahi schools. In India, the Anahabi school predominated but was continually adapted to local practices. Halak emphasized that pre-modern Sharia was not a codified system of rules but fluid, moral legal discourses grounded in juristic reasoning. During Mughal period, formal law was supplemented by Zawabit, imperial edicts, and non-Muslim communities retained autonomy in personal matters. This produced a syncretic legal order in which Hindu-Muslim personal laws coexisted with minimal antagonism, mediated by local institutions and social consensus. This reflects that both in Hindu and Islamic tradition, personal law was not a static or a codified body imposed by the state, but a dynamic, negotiated practice embedded in community norms and evolving jurisprudence. The idea of fixed, state-enforced religious laws was largely alien to this pluralist legal order. Instead, the law traversed communal, regional, and caste boundaries, adapting a local context and customs and all that. I think you should really understand that before British arrived at India, we were kind of following plural legal traditions. Islam, there's one school, different schools of thought, and then Hindus and all that. Even local traditions were kind of dominated all that. Okay. Then came the Britishers. British colonial rule disrupted this plural legal ecosystem by codifying personal laws into fixed textual forms, motivated by administrative convenience, efficiency, and legal certainty. Colonial jurists redefined Hindu and Muslim Islamic laws as Anglo-Hindu and Anglo-Mohammedan systems, relying not on lived practices. I think you should really understand that, how the British actually established the legal systems. Not on relying not on lived practices, but on selective textual interpretations. Okay, I think this is a crucial point where we
how we arrived at all that. Colonial codifications restructured Hindu law, bounded Brahminical scriptures such as the Manusmriti, thereby marginalizing matrilineal traditions and regional variations, right? Then this process of legal textualization produced a homogenized and upper caste version of Hindu law, one that bore little resemblance to the historically diverse and plural practices it perpetrated to represent. While reformers such as the Hindu Widow Remarriage Act 1856 appeared progressive, true, as Latamani argues, within the very Brahminical logic it sought to mitigate. The broader effect was that entrenchment of patriarchal norms and the suppression of interpretive flexibility inherent in the traditional Shastra-based system. Islamic law underwent a similar narrowing. Colonial rules privileged a textualist reading of the Hanafi school, primarily through the Hidayah, and sideline juristic tools like Ijtihad or independent reasoning and customary diversity. I'm so sorry, I couldn't kind of pronounce it properly, but the whole point is kind of about this independent reasoning, okay? And then customary diversity. So as Nandini Chatterjee demonstrated in her work, colonial court system systematically replaced Qazi-led adjudication with centralized, formalized British-style courts, eroding community-based dispute resolution, right? The Muslim Personal Law Sharia Application Act of 1937, though ostensibly aimed at preserving Islamic identity, paradoxically imposed uniformity across diverse Muslim community. I think this is a very important point actually. We can kind of discuss at a later stage. Now, Haller described this transformation as the death of Sharia, a process through which colonial rationalism stripped Islamic law of its ethical dynamism and community-rooted authority. The deeper impact of colonial codification was epistemic. Law was transformed from flexible, negotiated social practice into a rigid marker of religious identity. Aisha Jalal notes that colonial state elevated scriptural orthodoxy while ignoring the lived interplay of text and customs, thereby constructing Hindu and Muslim law as mutually exclusive, essentialized domains. I think that you really need to understand this. The British system actually kind of played the way we sort of living now, and now how we understand the caste structures and all that. Although colonial authorities occasionally acknowledged customary exceptions, they ultimately embedded a binary legal architecture, Hindu versus Muslim, into the foundation of the post-colonial legal order. So this colonial legacy continues to haunt contemporary legal traditions as well. Now, so the formal inauguration of the Constituent Assembly on 6th November 1946 marked a defining moment in India's constitutional history. Though constituted under the Cabinet Mission Plan, I think I don't have to kind of go into all these details. So it's basically essentially, Branwell Austin has noted, this was the first time Indians were responsible for their own governance. Now, earlier they were kind of governed by the rules and regulations of the Britishers. Now this is the first time that they came together and they sort of responsible for their own governance and free to pursue their long proclaimed aims and aspirations. Yet these aspirations unfolded amidst deepening communal fractures. The Congress rejection of compulsory provincial groupings, sir, actually I already mentioned this, in July 1946, as Aisha Jalal argued, shattered the Muslim League's hopes of provincial autonomy. There's under this Muslim plan, there's this the three federal structure in a way. So that earlier Congress was kind of agreeing, but then afterwards provincial based, they didn't want kind of give that autonomy to the provinces and all that. So accusing the Congress of negotiating in bad faith, Muhammad Ali Jinnah withdrew the legal league from the Constitutional Assembly on 29th July 1946 and called for direct action, leading a decisive collapse in the constitutional process. Despite this impasse, the Congress went ahead with the proceedings of the Constituent Assembly. So, to navigate the complex challenge of constitution making in a deeply plural society, the Constituent Assembly established the Advisory Committee on Fundamental Rights, Minorities and Tribal Excluded Areas, chaired by Vallabhbhai Patel. This committee in turn created 5 subcommittees, including the Subcommittee on Fundamental Rights. So, anyway, essentially on the Uniform Civil Code debate, there's a 2 particular subcommittee proceedings were kind of important. One is kind of subcommittee on fundamental rights. The other one is kind of subcommittee on minority rights. So it was in the deliberations of the subcommittees, these 2 subcommittees on fundamental rights. It was Minnu Masani first advanced a formal proposal for a UCC, Uniform Civil Code, thereby initiating its constitutional journey. He argued that religion-based personal laws hindered India's progression towards legal modernity and national cohesion. I'm trying to kind of draw these ideas. I want to kind of you to focus on these, because if you look at every stage wherever this Uniform Civil Code coming and all that, either during the Constitutional Assembly debates or in post-colonial or post-independence judiciary initiations, or even in the Uttarakhand in experiment, you would see that the similar arguments are being repeated now, rehearsed now. So the original idea is actually kind of intact. So one is kind of uniformity, because we are trying to kind of build a nation, and then the other side of the picture is kind of basically how can you kind of reject us because we are God-fearing, or kind of our customs we draw from religion and all that. These are the 2 terrains actually kind of you see that arguments are built around this Uniform Civil Code. Okay, so then, although the proposal was supported by Rajkumari Amrit Kaur, Ansa Mehta and Dr. B.R. Ambedkar, the subcommittee on fundamental rights ultimately rejected it on the ground that the subject law beyond the scope of justiciable fundamental right. This decision reflected the subcommittee emerging distinction between justiciable rights and aspirational principles. On 30th March, it resolved to place the UCC within the directives of state policy. Clause 41 of subcommittee's draft report read, the state shall endeavour to secure for the citizens a uniform civil code. The directive principles articulated the moral goals of the constitution without conferring enforceable rights. Right? In this spirit, the UCC was framed as an ideal to be pursued, not imposed. In contemporary political discourse, this aspiration often finds expression on slogans such as "One Nation, One Law." Yet, even in 1947, the implications of such uniformity raised serious concerns. Would legal uniformity erase entrenched normative framework that structured personal life? Could such a code override long-standing religious customs? Crucially, what did it mean for minorities whose personal laws were integral to the identity and belief? Now, you should also understand, when the Uniform Civil Code was being discussed in the Constitutional Assembly of India, because of this partition, a majority of the members who elected through the Muslim League party, they migrated to Pakistan. A large number of people. Now, that way, whoever they, I think largely from Madras Presidency, Muslim League, whoever elected, they remained, but largely from the North Belt, they traveled to Pakistan, right? And so actually lost their negotiation ability to negotiate and all that. Earlier, the Congress would kind of negotiate with Muslim League, with regard to this issues pertaining to Muslims. But now they are emboldened. Now they are kind of 82% of the 82% of the members in the assembly kind of belong to Congress. Therefore, previous term Modi, they don't have to kind of consult with any of their opponents and all that. We want to kind of do or bring any law, we will do it. That's the kind of atmosphere. Of course, Nehru still, and then other people who kind of they were inspired by this democratic ideals. But still, I would say that because of their number, you would find that Muslims were kind of marginalized, definitely. Now, by April 1947, the Uniform Civil Code had become a site of contention between the Subcommittee on Fundamental Rights and the Subcommittee on Minority Rights. So, while the former endorsed it as an instrument of national integration, then and active and civic rationalization, while the later struck a more cautious note, in its interim report of 19th April, the Minority Rights Subcommittee described the UCC as eminently desirable, but insisted that it should be adopted entirely on a voluntary basis. And I think you should really understand where these ideas are coming from. On the one hand, Fundamental Rights Subcommittee wanted kind of because it's great actually, because what is that instrument of national integration. The moment that you follow separate laws, then you are unable to kind of integrate along with other people, right? You will be kind of all the time claiming your separate identity. But whereas if you follow the same laws, then there is a possibility for this national integration and all. We don't want any separatism as such. Okay, civic nationalization and all that. Then whereas kind of yes, we agree on that point, but at the same time, it should kind of happen on a voluntary basis, rather than kind of imposing something, by the state, right? So the personal laws, the report argued, were not merely legal provisions, but cultural expressions embedded in community life. And imposing uniformity risked alienating the very minorities whose trust the Constitution sought to secure. For some members, however, this compromise was intolerably timid, right? For example, Amrit Kaur, Hans Mehta and M.R. Masani filed a sharp dissent bristling with impatience, at what they regarded as the Subcommittee on Fundamental Rights evasive responsibility. They objected in particular to the majority's relegation of the UCC to an ultimate social objective rather than binding constitutional guarantee. It's not guaranteed. Once you kind of place this idea in the principal state policy, it's not binding, unlike fundamental rights, right? So, in their view, this amounted to hollow window dressing. I think it's sort of this argument coming from this, even that criticism against this principal state policy, right? They are all kind of window dressing, rather, right? A gesture that paid lip service to reform while retreating from its imperative, retaining religious-based personal laws, they argued, was not accommodation but a betrayal of the project of nation building itself. Okay, so long as such laws endured, India would remain divided into watertight compartments: Muslims versus Hindus or Christians, right? Shackled by communal boundaries. They therefore urged the UCC be enacted as a binding constitutional mandate within 5 years. They wanted this constitution. They wanted the members to enact it within the 5 years of the constitution. Now, so this was kind of a subcommittee level and all that. The main arguments actually kind of evolved or discussion happened in the Constitutional Assembly when the law was when the article was draft article was brought into the Constitutional Assembly. So during these debates, particularly Naziruddin Ahmad, Kokar, Mahbub Ali Bey, all these Muslim League members and Hussein Imam, they mounted a multi-layered critique of the UCC, Uniform Civil Code draft article, grounded in democratic theory, comparative constitutional analysis, and cultural pluralism. Okay, their opposition was not rooted in an absolute rejection of reform. Instead, they want that a centralized, immediate, cohesive UCC risked producing a form of legal majoritarianism that would undermine democratic inclusion. Focus invocation that it's not democracy at all, it is a tyranny. Like the moment that you are sort of asking minorities to follow certain law, uniform civil code, you're not really kind of negotiating, you're sort of imposing, right? So it's not a democracy at all, it's basically essentially tyranny. If the majority rights roughshod over minorities, captured this central anxiety. Their argument was that majority-driven uniformity could easily disguise itself as neutral law while actually codifying the values, customs, and social norms of dominant group and all that. So, I mean, one person is kind of, okay, we agree with the uniform civil code, fine. But what kind of, whose law you would kind of impose and all that? Is it kind of Muslim law to be prevailed? Is it kind of, which law we have to practice? Is that, Hindu laws? Or Christian laws or Muslim laws? Whose laws we have to prevail? Then obviously because like the Muslim Hindus are majority number, those are kind of at least the Muslims thought that they are being imposed on them. That's the logic of their argument. So this resonates with Viku Parekh's critique of false universalism, where a dominant culture's practice become not legally universalized in the name of equality, thus marginalizing minority identities. The Muslim members insisted that the law should not be merely erase differences in the name of civic unity. Instead, it must ensure that all communities feel recognized and respected. So it's essentially, the Charles Taylor's argument of respecting and recognizing the difference in all that. Okay. Whereas the majority argument is kind of universalization, like hereafter we will not kind of have this sort of differences. Like you could, let's not kind of talk about you are Hindu or I'm Muslim or I'm Christian and all that. Hereafter we are kind of one nation, one law, so therefore we are one people and all that. That's the kind of argument, right? There's an interesting debate actually if you kind of try to look at this. The principle of cultural recognition became a recurring theme. Hussein Himam stressed that even if the Uniform Civil Code promised equality, the apprehension felt by the members of the minority community is very real. Here, the argument touches on a deeper philosophical concern that legal reforms, even when substantively equal, can generate symbolic injuries by invisibilizing or diminishing the cultural identities of minorities. Right? This view parallels Charles Taylor's politics of recognition, where misrecognition by state institutions inflicts a form of civic harm. I mean, it's essentially, if you kind of look at this uniform civil code debate, either in the Constitutional Assembly debates or kind of even now, it's like akin to the debate that has been kind of happening, will happen around this hijab case also, right? So Naziruddin Ahmad added another dimension by questioning whether it was reasonable or even socially feasible to expect communities to abandon long-standing religious practices of marriage and family law overnight. It's essentially kind of the historical idea, right? We have been kind of practicing, following these customary laws, which are kind of drawn again from religion for centuries together. Now you come here and then suddenly ask you kind of follow something else. Is it possible? That's kind of reasonable question that he was asking. Then his emotionally charged warning that a hasty UCC could invalidate rigorously valid marriages and bastardize the children born highlighted the potential real-world consequences of legislating family life without social preparation. I mean, you need to kind of have some kind of preparation, right, for anything. Not just kind of this one, but even this here also. So another stand of the minority critique centered on secularism as state restraint, not state-driven homogenization. So for instance, like Ahmad and then Booker argued that true secularism requires the state to abstain from intruding into religiously grounded legal traditions unless there is a clear consent. Now I think that you should really understand this in the sense the secularism. So both the parties actually kind of came up with this idea of secularism. On the one hand, this Muslims who are saying that since we are adopting or we have been kind of the whole idea of constitution and then secularism. So therefore, secularism is kind of giving equal respect to all the religions, right? And then the majority idea is kind of completely different and all that. No, so that's the exact point. We want that equal. Secularism doesn't mean that differentiation. Where secularism means equality. That's a very interesting in all that. Then they saw draft Article 44 as contradicting Article 90's guarantees of, draft Article 19, now it's Article 25, of religious freedom and feared that its placement in the death principles could undermine enforceable fundamental rights. Who knows, at some point of time, they worry. At that point of time, it was fundamental death principle state policy. They're also worried, like, the moment that you keep this death in the death principle state policy framework, somebody might kind of want to bring it to the fundamental rights and they want to kind of impose that. What you do at that point of time. It became that fear actually became a reality now. Their concern was that the constitution might embody an internal contradiction, guaranteeing religious freedom on the one hand and encouraging the erosion of religiously grounded personal laws on the other hand. I think it's kind of genuine concern, right? You are saying that through Article 25 that right to religious freedom. So right to religious freedom kind of not just about practicing your God wherever you are, but it's also like religious practices, right? That's also including this if your social life kind of draws from your religion, then obviously that also can have some implications, right? That's what they're saying that on the one hand you are giving this right to religious freedom absolutely beautifully right, but on the other hand you are kind of constraining us like no, you should follow this marriage and then succession act now. You should follow exactly kind of what other people are kind of following. So therefore there is no religious freedom as such. Even if there is it's kind of the religious freedom enjoyed by the Muslims would be completely different from religious freedom enjoyed by other communities would be different, right? So against these critiques, the principal proponents came Munshi, Aladi Krishnaswamy Iyer and Ambedkar. Ambedkar actually in favor of UCC. Advanced an equally compelling set of arguments. Their case for the UCC rested on constitutional rationality, civic equality, legal modernization, and gender justice. Okay, Munshi argued that the fears of majoritarian imposition were misplaced because Hindu personal law itself was deeply fragmented across several schools like Vitakshara, Dayabag, and Mayuka. In his view, the adoption of a UCC would require Hindus themselves to surrender long-standing intra-Hindu diversity. Whatever that you are going to say that even for Hindus is not easy because different sets of communities following different sets of these laws. Therefore, even for them actually it's an imposition. Okay. Thus, far from being a project of Hindu dominance, the proposed code required the majority community to give up entrenched customs. He insisted that the UCC was not an attempt to exercise tyranny over minority. It is much more tyrannous to the majority. This reframing casts the UCC not as a vehicle of assimilation, but as a collective national project requiring sacrifice from all communities. So your nation demanding your sacrifice, that kind of an argument, right? Now, Munshi also placed the UCC within a broader post-colonial framework. He argued that British colonialism had frozen fluid, evolving personal laws into rigid religious categories, creating a pseudo-pluralism that entrenched difference instead of enabling social reform. So UCC would dismantle these colonial remnants and allow India to rebuild its legal system on principles of civic equality and rationalization. In this reading, the UCC was a means of decolonization, not homogenization. Very interesting that quite often that even in the current dispensation, you find that one is kind of uniformization, homogenization, and then also decolonizing aspect. For example, like the name Bharat, right? Now, so we are familiar with this, India, well, English language, and then maybe in Telugu, we have our own local name, right? So when in 2023 that G20 movement, in the international fora, the government came up with this idea of Bharat Pradhan Mantri, Bharat Rashtrapati. Right? Earlier, kind of in the international fora, they would kind of refer India as a India. Although the Article 1 actually kind of says both India, that is Bharat, but they specifically kind of used the Bharat at that point of time. What they said, like using this idea as kind of decolonization, like the India as such kind of name is kind of being imposed by Britishers. Therefore, we have our own name, Bharat. In that Bharat, if you kind of see that, it actually excludes a lot of people, a lot of communities. Bharat actually, then you trace the tradition of like Bharata, Bharatavarsha, Bharatkhanda and all that. That Puranic tradition, the Mahabharata and all that. Now in that, where the other people are, Muslims, where are they? Where are the Christians? Where are the Dalits and all that? So when you say that, these terms actually reflect something and all that. I think one need to really understand like what these terms refer to or convey the meaning. Okay. Now, Alladi Krishna Swami Iyer added a constitutional argument that the directive principles were intended to guide the future evolution of India's legal system. So therefore, a UCC placed under DPSP would allow the state to gradually harmonize personal laws without overriding religious freedom immediately. So this placement allowed for institutional patience and democratic persuasion rather than judicial coercion. Now, so for Ambedkar intervention was perhaps the most influential. So he countered the idea that Muslim personal laws was ancient, uniform, or immutable. This one of this argument of Muslim personal law, Muslim League was that we have been following these customary laws through our religion for centuries together and all that. So he debunked that idea, that argument and all that. He demonstrated that many Muslim communities historically followed Hindu or customary laws until the 1930s. And that the Sharia Act of 1937 itself imposed a new uniformity from above. This undermined the claim that reform of Muslim personal law constituted a religious violation. It's not. Because like 1937 only Sharia law was being imposed uniformly across all the Muslim communities. So how can you say that this is kind of being imposed and all that? This violates Islam religion and all that. It's not. So Ambedkar also emphasized that civil uniformity already exists in areas like the penal code. Doesn't matter whether Muslim or Hindu or Christian or penal code applies equally to everyone, right? And then the Transfer of Property Act and the Criminal Procedure Act, making marriage and succession. So, making marriage and succession anomalies, the little corner. These are the two areas, what he said, little corner of the legal system awaiting harmonization. Yeah, except that everything's kind of seems to be kind of absolutely uniform. What the hell you are talking about? Ambedkar viewed the UCC not as a theological intervention, but as the completion of India's legal modernization. Okay. Now, what particularly striking is that despite the sharp disagreements, both proponents and then opponents, unlike today, where you kind of throw mic at each other or take the chase as well sometime, both the proponents and then opponents converged on one powerful principle. The legitimacy of personal law reform in a diverse democracy must rest on persuasion, inclusion, and negotiated consent. Muslim members like Hussein Imam acknowledged that uniformity of law is a desirable thing, but insisted that it must be evolutionary, not revolutionary. Okay? You see this contradiction. If you sort of impose, that's kind of becomes a revolutionary. But if you kind of give space and then if you try to implement it one after the other, then that's kind of evolutionary process and all that, right? Similarly, even while strongly defending the UCC on merits, Ambedkar maintained that the placing it in the directive principles were essential to avoid coercion and to ensure constitutional coherence. Okay, this underlying consensus created a form of what the article calls consensual constitutionalism, a commitment to reform through persuasion and participation rather than majoritarian imposition. So I'll take another 10 minutes maximum. So please be patient with me. So then, okay, let's kind of know. I want to kind of very quickly move on to this. How the Indian judiciary settled, or intervened or interfered or kind of discuss, take up this uniform civil code debate. So the Indian judiciary has, over several decades, maintained a consistent but nuanced position on the uniform civil code. The Supreme Court has repeatedly affirmed the UCC represents an important constitutional aspirational expression in Article 44 of the DPSP. In a series of landmark cases, most prominently Muhammad Ahmad Khan versus Shahbanu Begum, 1985, Sarla Mughal versus Union of India, 1995, and Lily Thomas versus Union of India. So these, and then of course later on Shahira Bano Tribal Talaq case, right? The court described a UCC as desirable for promoting gender equality, national integration, and a uniform framework of civil rights across communities. So the court often expressed regret that the promise of Article 44 remained unfulfilled and suggested that the absence of a UCC perpetuated discriminatory personal laws, particularly against women. What I really don't understand is that it's true. What they're kind of trying on the surface of it is true. But then in the direct principle state policy, there are several what you call articles, right? In the framework. So they don't really kind of touch upon these. But whereas they're kind of very enthusiastic in talking about this Article 44 only and all that. There are several provisions, right, in DPSP and all that. I have some problem with when they kind of when they don't touch upon this other things, and then when they touch exclusively on Article 44. Anyway, the point is that at the same time the court has drawn clear boundaries around its own institutional role. While it endorses the idea of a UCC, it consistently emphasizes that judges cannot impose or enact such a code. So in Pannalal Bansilal versus State of Andhra Pradesh, 1996, the court clarified that Article 44 is non-justiciable directive principles, and decisions regarding UCC must be taken by the legislature when social conditions were appropriate. Thank God. Okay. The judiciary therefore, or thank judges. The judiciary therefore supports the concept but recognizes that the political branches, not the courts, must determine the timing, consent and process of implementation. The earlier argument, right? Due process versus according to the law, right? Or the legislative point. A second stand of judiciary approach is the insistence that even without a UCC, personal law cannot entirely escape constitutional scrutiny. Where personal laws intersect with secular civil consequences, the court has increasingly applied fundamental rights principles, particularly equality and dignity. This trend culminated in Shahira Bano versus Union of India, where instant triple talaq was invalidated as arbitrary and unconstitutional. Through such decisions, the court has slowly pushed personal law reform in a right-based direction, even as it refrains from imposing uniformity across the board. Now, more recent judicial comments reflects a shift from earlier forceful exhortations toward a more cautious and social sensitive tone. The court acknowledges that personal laws are deeply intertwined with cultural and religious identity, and that reform must proceed Rather than advocating abrupt, sweeping uniformity, the court now appears to favor incremental reforms within communities guided by the constitutional equality mandate. Overall, the judiciary's position balances principles with restraint. It views the UCC as a desirable constitutional goal that can strengthen equality and secular citizenship. It maintains, however, that only the legislature has the authority to enact such a code, and that courts must not overstep by attempting to legislate from that bench. Simultaneously, the judiciary continues to ensure the personal laws, when they give rise to civil consequences, conform to fundamental rights. In this way, the Supreme Court promotes gradual, constitutionally grounded reform while leaving the broader policy decision on the UCC to the democratic branches of government. Now, the juicy bits now. Uttarakhand. So, the Uttarakhand of the Uniform Civil Code, it marks a significant moment in India's ongoing debate on personal law reform, secular citizenship, and gender equality. As the first state to implement a comprehensive UCC, Uttarakhand has effectively translated Article 44, because obviously the court has been saying that it's not my domain, it's the legislature domain. So therefore they have taken a hint and then actually they did it through Uttarakhand legislature. It's amazing, no? The code seeks to unify diverse personal law regimes relating to marriage, diverse inheritance, succession, and living relationships into a single statutory structure applicable to all residents of the state, barring scheduled tribes who are expressly exempted in recognition of their constitutional protected cultural rights and all that. It's very interesting, right? I mean, essentially, they're only allowing this constitutionally protected cultural rights to the Adivasis, not the Muslims and all that. Article 29 or 28 talks about cultural rights of the minorities, right? So it's fundamentally violates this, right? At the heart of the code is the principle that civil rights and obligations should not depend on religious identity, the uniform civil code. To that end, it introduced uniform minimum marriageable ages, mandatory registration of marriage and divorce, and a prohibition on practice such as polygamy that are considered incompatible with constitutional norms. It also provides equal inheritance rights to sons and daughters, abolishing gender-based distinctions that persist in several personal systems and all that. Now, whoever listening to this, they would say that, fantastic, what are you talking about? It's an amazing act, right? One of its most innovative and controversial features is the compulsory registration of living relationships. Now, you might say that, we are 21, we are adults, we grown up people, we can do whatever we want. But the court insisting that, okay, very nice, okay, you are you want to live in relationships, fine, but you have to register and all that. You will also inform your parents. That's what this court is saying. The law is saying, right? Now, couples are required to submit their details to a designated authority, which may verify the information, and the law extends rights relating to maintenance, legitimacy of children, and protection against exploitation and all that. Absolutely, it's all in order to protect the weak and humble people. Eventually, if this guy deserts you, then there must be who is accountable and all that. State will, yeah. Even if you look at this Manadharma Shastra, all these avatars, right? 8 avatars and all that. It's basically essentially to protect when they say dharma and all that. Essentially here to protect the poor people or somebody weak. So the state is doing that its role and all that. A wonderfully worded document. Okay. So through these provisions, the UCC seeks to modernize family law, reduce ambiguity, and prevent the misuse of religious or customary loopholes to the detriment of vulnerable individuals, especially women and all that. It all gender justice and all, right? That's the argument of the states. Now the argument advanced by the advocates of Uttarakhand UCC centered around constitutional principles of equality, secular citizenship and the need to eliminate discrimination embedded in personal laws and all that. Of course, equal property rights and man and woman. Superb law, right? Now, proponents argue that India's personal law framework has historically privileged patriarchal structures, often denying women equal status in the matters of marriage dissolution, guardianship, inheritance, and financial security. Okay? They maintain that in a uniform code finally places constitutional morality above religious customary norms, ensuring that basic civil rights are consistent for all citizens. Advocates further assert that legal pluralism in family law has generated confusion, uneven protections, and opportunities for exploitation. For example, the use of religious conversion to contract a second marriage or avoid maintenance obligation. You know, Dharmendra Hemamali case is an interesting case, right? Dharmendra actually converted to Islam and all that in order to marry Hemamali, the man who died recently. In their view, the UCC ends such inconsistencies and promotes a coherent, secular and egalitarian civil order. They also contend that by clarifying procedures, defining grounds for diverse uniformity and ensuring compulsory registration through digital channels, the code simplifies family law administered and reduces litigation driven by ambiguity or overlapping systems. Now, the opponents, it would be interesting actually to see that. Opponents, however, raise pressing concerns about religious freedom, privacy, and the risk of cultural homogenization. Now, critics argue that personal laws are closely linked to the cultural and religious autonomy protected under Article 25 to 29 of the Constitution. But basically, the source, if you look at this now the current arguments, look at the Constitutional Assembly debate, same arguments actually. The context differed, but then actually essentially the arguments are the same. They fear that although framed as uniform, the code implicitly mirrors the structures of existing Hindu family law and therefore imposes a majoritarian legal culture on minority communities. The exemption granted to scheduled tribes, while constitutionally justified, has also been criticized for undermining the claim of full universality. You say that this is for universality, homogenization and all that. Fine. If you say that universality, then why are you excluding Adivasis? There you are actually kind of separating, right? In the sense that you are giving a space. So therefore, there is no universality at all. A major point of contention concerns the compulsory disclosure and registration of living relationships and all that. Okay. That has kind of huge implications, right? So, I mean, in India, especially like where we are kind of concerned about our social prestige, social status and all that, parents' worries and all that. Would any kind of living relationships kind of people would go to a legal authority and register themselves that we are seeing each other, therefore we are living together and all that. It's a problematic concern, right? Problematic issue, right? Scholars and activists warn that such provisions may expose couples, particularly interfaith or intercaste partners, to surveillance. Now, it's kind of, that's the whole point, right? Anyway, marriages, interreligious marriages, kind of, they are trying to kind of prevent. Now, couple who are kind of living, Muslims or kind of Hindus, kind of different religious people living together, kind of, they want to kind of I don't know, I think the police these people. That's the whole idea behind this. Okay, social pressure or harassment and may violate the fundamental right to privacy, negotiating, recognized in the Kutswami judgment. And I'm sure like you must have come across these things like by watching reels and all, because like a Muslim girl or Muslim boy kind of going out with different community and these our vigilante community, right? They sort of stop people, and then how dare you to kind of go with our girl, how dare you to kind of go out with our boy and all that. These are the things that become very, very common, and it's not in kind of Uttar Pradesh and Uttarakhand now. I think here also in Karnataka, even in the south, it's kind of spreading like a cancer, right? And I would say that. Now, There are also concerns about the transition from multiple personal law system to a single code. Critics note that the shift raises questions about the status of marriage contracted under earlier laws, the fate of property arrangements established under old rules, and the potential for conflict between state legislation and central laws such as Special Marriage Act or the Indian Succession Act. They argue that implementation may strain administrative capacity and generate confusion unless accompanied by careful public education, phased transition plans and robust procedural safeguards. So, I just want to conclude this. I mean, there are several other arguments are also there, but in the course of the discussion, if you have any questions, I'd be happy to dwell on that. So finally, what I want to say that across constitutional, judicial, and legislative history, you look at from the Constitutional Assembly debate, and then you have the judiciary, and then you have this Uniform Civil Code. So the Uniform Civil Code has remained a site where competing imaginaries of citizenship, gender justice, secularism, and national identity intersect. What I try to demonstrate is that UCC debate cannot be reduced to a simple opposition between progress versus and tradition, equality versus religion, modernity versus pluralism. I mean, not versus and pluralism. Instead, it must be understood as a deeply constitutional question. How can a diverse democracy pursue gender-just reform while remaining faithful to its pluralist foundations and the moral discipline of constitutionalism? I think this is a fundamental question that everybody has to pay some attention. So, three overarching insights emerges. First, the Constitutional Assembly conceived Article 44 as an aspirational and dialogic project grounded in persuasion, inclusion, and institutional patience rather than statutory compulsion. The minority members' sophisticated warnings about majoritarian legal dominance, cultural misrecognition, and democratic legitimacy were met not with refutation but with an equally principled acknowledgement by Ambedkar, Munshi, and Iyer that the UCC must proceed through social readiness, not imposition. The Assembly therefore placed Article 44 among the judge principles, signaling a constitutional ethic of gradualism and participatory reform, a nuance often ignored in later political and judicial rhetoric. The uploaded text, and then the Supreme Court's jurisprudence shows two parallel trajectories. On the one hand, cases like Sabanu, Shamim Ara, and the Shaira Banu advanced gender justice within personal law, demonstrating that constitutional equality can penetrate family law without abolishing pluralism. You have shown this through this Shabana case, Shaira Banu. You don't have to make a grand legislation on that. Wherever there's discrimination against women, then the law will take its own course, right? That is what Shaira Banu and Shara Banu demonstrated. On the other hand, decisions such as Sarla Mukta revealed the dangers of converting gender justice into rhetoric of majoritarian nationalism by mischaracterizing minority norms, an obstacle to national unity. Over time, as the court became more attuned to autonomy, dignity, and privacy, particularly after Swami, Navjot Johar, and Joseph Schein, its approach shifted towards incremental, internal, and rights constrained reform rather than calls for sweeping uniformity. Right? Now, Uttarakhand Uniform Civil Code is a turning point. For the first time since independence, the state has legislated a comprehensive code that claims uniformity across communities. While the Act contains several progressive provisions, now I thought you guys know you are tired. Just last 1 minute. Gender equal inheritance, mandatory registration, and uniform grounds for divorce. It also raised profound constitutional concerns. So the Act risks reviving precisely the dangers that framers sought to avoid. Right? The use of uniformity to override cultural autonomy, the centralization of state power over intimate life, and the marginalization of minority communities under the guise of neutral land. They the right-wing, course is actually kind of entered everywhere, right? They entered into our food, beef you shouldn't eat and all that, you should not kind of wear hijab, and now we kind of know about the marriage and all that, everywhere they entered and all that. There is no space where they did not kind of enter. Most now through this uniform civil code, Uttarakhand Uniform Civil Code, they entered into intimate relations, that space as well. They're kind of surveilling, they're controlling and all that, they're supervising and all that. Now you have, if you are a Hindu, you have to kind of go with this Hindu only. If you are a Muslim, you should kind of go with the Muslim. That kind of controlling and all that. They enter that space now. No, at the end, we say that we have democracy, we have consent, we have personal laws, and not personal law. We have kind of freedom and all that. All that seems to be kind of we don't accept and all that. You have confined to this laws. This is where we agree. So, in short, although Uttarakhand has initiated a bold experiment, its model demonstrates how uniformity, when legislated without dialogue, can risk sliding into a form of legal majoritarianism. I will stop here. Thank you so much for your patience. Thank you for your class. Any questions or anything that you want to take forward, or you're done for the day? I think they're ready for give the vote of thanks. Alright, please. Thank you guys.
I request Dr. Banerjee sir to facilitate Dr. Shambhaya Garu. Good afternoon to everyone present here. I am Danyadipika from the School of Law, VIT. It is my honor to deliver the vote of thanks for today's section. First and foremost, I express our sincere gratitude to Dr. Shambhaya Garu, Associate Professor of Politics, Career University, Sri City, Andhra Pradesh, for taking time out of his schedule to be with us. Sir, your insightful talk on Uniform Civil Code on constitutional morality has truly enriched our understanding. The clarity, depth and perspective you brought to the topic have given us much to reflect upon as in-law students. I would also like to thank our faculty members, coordinators and the organizing team for making his section possible, and heartfelt thanks to all the students for being such an active and engaged audience. Once again, thank you Dr. Shambhaya Garu for sharing your knowledge with us today. Thank you everyone.
Thank you very much, guys. So now for 2 minutes, guys, just few housekeeping matters. Thank you very much for your patience and sitting a long day. I'm sure it is being a long day. Confining into here and making you to become overnight a constitutional expert. And whether you like it or not, and you have to become a constitutional expert. You must try to learn the vocabulary and the language of what the people are speaking. Guys, my left, I could see that there is a little bit of inconveniences. Just give me 2 minutes, we'll wind up. Your attendance will be taken. There are 2 things you will have to understand. Tomorrow also we are going to have, and we'll also recite our preamble, and that is a mandatory, number 1. Number 2, and since you are reading legal and constitutional history next semester, and now this semester you are reading legal and legal methods, legal and research methods. All the